Okay, folks, I'm back. We are continuing with our lectures on the IRAC method. By now, you have done the assignment from last week. You have read my brief on Mark Sargent. You have read the court's decision on Mark Sargent. You have seen the oral arguments on Mark Sargent. You are sick and tired of Mark Sargent and authentication, I know. But the idea here was to have you do this assignment first and then to read my brief and look at the decision and then to compare your work to my work. And the idea was for you to read my brief and say, oh, that's what Kidd did. I see how he applied the law to the facts. That's how he did it. And that's what I wanted you to get out of it. Okay? So what I'm going to do now is just quickly go over the Mark Sargent brief to highlight the parts of the brief that are instructive to you folks. Okay? I'm going to stop here for a minute. Okay, here is my Mark Sargent brief, my opus, my work of art. I'm sure it had you thrilled. I'm sure you laughed, you cried when you read this. It's a page turner indeed, ladies and gentlemen. Okay, so going right to the facts down here. So we start our memorandum of law with the facts. Remember, I told you it's very important to tailor your facts to the legal issue at hand. Do your research, figure out the issue, what the issue is, and write the facts around the issue, not the other way around. Do the research first. In this case, you were assisting a prosecutor. We were a paralegal. The prosecutor's in the middle of the trial. The judge has heard all of this evidence about this burning of the building and about this arson and about this defendant and so on and so forth. He is interested in one specific issue, and that is the issue of authentication of this particular letter that this defendant wrote to his probation officer. The judge has heard the facts, all of the facts. He doesn't need you to recite what every witness said in the trial. So your job in writing the facts was to tailor for the judge facts that would assist him in determining the issue of authentication with respect to this letter. So you go to the facts of the letter. Let's go down here. You see, I have all these extraneous facts in my brief here. You didn't need a lot of these because I had two issues in my brief. You only had one. For reasons that I don't need to explain now, I had to summarize the entire facts of the case. I had a second issue, which was that the defendant said there wasn't sufficient evidence to support a probation violation. So I had to review all the evidence. You were only dealing with issue one. So you just needed to skip down in here to the place where it talks about the letter. And here it is here. It's this paragraph here. You just needed the information from this paragraph and the next paragraph that talks about this letter, its contents, the fact that it's signed by the defendant from the Plymouth County House of Correction. The defendant is in fact in the Plymouth County House of Correction. It has his unit number and ID number on it. And then you could put this in here. This is how the letter came about to be. Well, the judge knows this. Actually, you don't need to put this in here about how it came into evidence. And then you notice I put in your fact pattern for your assignment. You'll notice I put in there that the defendant, when he wrote the letter, referred to this jerk prosecutor Kidd. He knew who the prosecutor was on his case. He also referred to his case and described the specific details of his case. He talked about his criminal record. Why do you think I put those facts in there, ladies and gentlemen? It's because I knew you were going to be smart and you were going to be like Rob and you were going to do your research and you were going to say, okay, I got to help this prosecutor. Where am I going to find the rule that's going to help him? And you came across this rule and it's set forth in many different cases. And the rule says that there is no necessity for a handwriting expert to authenticate a document. A document can be authenticated through entirely circumstantial evidence. And a document can be authenticated through its distinctive contents, showing that the author of the letter is the only person who would have been aware of those factual statements within that document, right? You would have seen that rule to say, and you would have said, "Oh, I see. Oh, so it's like, you know, if it walks like a duck, quacks like a duck, it's got to be a duck, right?" And you would have said, "Okay, so I've got this rule, and I've got this letter here, and a kid's hypothetical says this defendant." Wrote this letter and he talked all about his case and his probation record, his criminal record, and so on and so forth. It had to be, so that shows that it had to be this defendant who wrote the record, who wrote the letter. Okay, so you would have done your research and you would have put in all those facts that help you. You would have looked at my hypothetical, my brief, the facts that I gave you in the hypothetical, and you would have said, okay, kid, he talked about this guy, he talked about this guy's calling kid out in the letter. He doesn't like the prosecutor. That's perfect. I should put that in there because that shows it's him. And he's talking about his criminal record. That's another important factor. I got to put that in there. Okay, you understand that? So that's what you're doing when you write these facts. You're selecting the facts that are relevant to your issue. All right. So let's go to the argument section. And in the argument section, we use the RAC method, RAC, rule, argument, conclusion. We've already done the issue. The judge has given you the issue, and that's authentication. So you do the RAC, rule, argument, conclusion. That's what I did here. I have a lot of extraneous law here. I'll just jump down to the important rule that I cited here. Okay. And here is the paragraph here where I started citing the rule, okay? A judge making a determination concerning the authenticity of a communication sought to be introduced in evidence may look to, quote, the confirming circumstances that will allow a reasonable jury to conclude that this evidence is what its proponent claims it to be. Commonwealth versus Purdy. That was a big case that was cited in a lot of these authentication issues. And most importantly, this rule here, evidence may be authenticated by circumstantial evidence alone, including its appearance, contents, substance, internal patterns, or other distinctive characteristics, okay? And that's the rule I applied. And now I'm going to go down to show you where I applied it. I started this is my application paragraph right here. All this is going to be application, the A. So I take that rule and I say the appearance, contents, and distinctive characteristics of the letter in this case provided the judge with ample evidence to support a conclusion by preponderance of the evidence that the defendant before him was the author of the letter. I want you to notice a little thing that I did here. I took that phrase up here, the appearance, contents, and substantial internal patterns or whatever, and I kind of mimicked it down here in my argument. I said the appearance, contents, and distinctive characteristics of the letter in this case provided the judge with, etc. That's a tip for you. When you apply a lot of the facts, I find it's a good idea to grab a phrase right out of a case that like I just did and stick it in there and then apply it to your facts. That way the reader, the judge, gets to this paragraph and he says, oh, appearance, contents, and I just heard that kid just talked about in that case. All right, so he's applying that rule to these facts. Tips off the judge as to where you're going. So now all of the rest of my paragraph here is that rule of the appearance, distinctive characteristic, blah, blah, blah. All I do for the rest of my argument here is I tick off every single fact that makes this a distinctive letter that only this Mark Sargent could have written. All that's the distinctive stuff, you know, the return address, his name on the envelope, his unit number, the fact that he wrote it to a probation officer who was his probation officer, John DeJesus was his probation officer, the fact that he, all the details in the letter, he knew who his attorney was, he talked about the burning of the building and details that only the burner of the building would know, all on and on and on, all on and on, okay? So that's all I had to do here, all right, to apply the law to the facts, okay? And I did that, and at the end of that paragraph, what I should have done, the right thing to do, and I want you to do, is have one conclusion sentence, and the conclusion sentence should say, therefore, the rule of authentication dictates that this letter should be admitted into evidence, or something like that, or the rule of VJ Sinha, whatever that case was, would support an inference that this letter was authored by this particular defendant. It's got to be a therefore sentence at the end of it. All right, I don't do that's the conclusion part that you have in your memo. It's implicit in a lot of the arguments. A lot of times the legal writers don't have a specific conclusion sentence. Some do. I think it's a good habit for us to get into in this class because it's just a good logical technique to use. Okay. The other thing I want to talk to you about is after you've applied the rule, you want to find cases. After you've applied the rule, what you also want to do is look at cases that seem to be like our case. And then you cite those cases too. So now you've applied a rule to the facts, but now you want to go find cases that are similar and say, look, this case was just like ours, and the court held that the letter was authenticated. Therefore, you should do the same thing, judge, in your case. And that's what I'm doing here. You look at this one here. I use parentheticals. I like parentheticals. It's a good technique. You know what a parenthetical is? You can see it right here. I cite the case, see Commonwealth versus Gilman, and then I put in parentheses the relevant holding from that case that supports my argument. Commonwealth versus Gilman. And then I say, conversations were replete with personal references, including pet names the defendant and the victim used for each other, references to events in which the two alone participated, supporting a conclusion that the defendant authored the Facebook chat messages. Okay? See what I did there? If you went to Gilman, you'd see that case is like ours in the sense that it's based on the authentication is based on the distinctive contents of the communication, just like my case. Okay? So I put that there. In Gilman, I think what happened was, I think it was maybe a child porn case or something where the defendant's sharing pictures with a juvenile, I believe. Or maybe, yeah. So anyway, the defendant's defense in Gilman was, well, how do you know it was me? I have a Facebook page. Somebody could have been on my Facebook page using my computer. I don't know. And I give my password to everybody, and everybody uses my blah, 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 blah. When then the Commonwealth made the argument, well, yeah, but you were using all these pet names that you were using for the victim and all this stuff. I guess the victim, he was sending the victim child porn or whatever. Okay, so that's a good technique to use, is the parentheticals. All right. Now we get to the end here, and you'll see at the end, we just have a conclusion at the end. Again, the conclusion at the end of our legal argument, the conclusion at the end of our brief or memorandum of law to the court is a form of a legal form. It's not the conclusion in the IRAC. It's simply that the court should do what I asked it to do. For the reasons herein set forth, the court should deny the defendant's appeal and uphold the finding of violation made by the trial judge. You're just restating what you want the court to do. So don't get the conclusion in the legal document confused with the conclusion in the IRAC. Okay? All right, so now I'm going to pause and I'm going to talk about the assignment, and then we're going to finish after that. Okay, the motion, the assignment that I gave you was to write a motion to the court with a supporting memorandum of law. You should know what a motion is. A motion is simply a document whereby you ask the court to do something. It's a simple document, and you're just asking the court to do something and cite a legal case that usually supports it. And then you have a supporting memorandum of law you submit with that. The memorandum of law is a more detailed document. It sets forth all of the case law that you believe supports your position and makes a legal argument that the judge should find in your favor. Okay? So you can use this motion and as a template, and this memorandum as a template. You can do it as follows. You're in Bristol County. You're in the Fall River District Court, the District Court Division, Fall River Division, or whatever, Commonwealth versus whatever the guy's name was in your assignment. And this is all boilerplate. So I need to educate you a little bit about criminal law for this. This is a standard criminal law motion that you might file in a lot of criminal practices in the Commonwealth. It's called a De Benedetto motion. Commonwealth versus De Benedetto says that that when the police apply for a complaint, the application for complaint must contain sufficient facts to support probable cause for each element of the offense. And if there are not sufficient facts for probable cause for every element of the offense, then the case must be dismissed before trial. So what happens is when the police arrest you, they apply for a complaint, they attach their police report to that complaint, and those facts are relied upon by the magistrate or the judge in order to determine whether or not there's enough evidence to issue a complaint against you. The judge or magistrate has to read that application for complaint and say, okay, tick off each element. Okay, there's enough facts for element A, there's enough facts for element B, and they put the stamp on it. Okay, we're going to charge kid with leaving the scene of an accident or whatever it is. Okay, that's a De Benedetto motion. So what in this particular scenario, I gave you an OUI case, a drunk driving case. Again, a very typical scenario in district court. And what you're doing here is you are going to make an argument that there's not sufficient evidence to support one or more of the elements for operating under the influence of alcohol. Okay? So I gave you a fact pattern in which I intentionally created some problems with the Commonwealth's case to give you some argument to make that there's not sufficient probable cause to support some of the elements. So your job in this motion, this memorandum, is to research the law, find out what the elements of operating under the influence of alcohol are, and then read the cases regarding each of those elements, and make a determination. Okay, has the Commonwealth met its burden here or not? Okay, so the way I suggested you organize your argument section of your memorandum is to simply make one section for each element. Okay, so you'd have argument, and then you'd have subheading A, and then you list the element A, whatever it is, blah 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 blah. And then under element A, you would state you've done your research, and you would state the rule for element A. In order for blah blah blah, there must be blah blah blah, Commonwealth versus such and such. All right, that's the legal rule, and then you just go into your RAC method, RAC rule, make your argument, and then your conclusion. Do the RAC method for each element. Okay, we know what the issue is. I've set forth what the issue is. Generally with the fact pattern. But so that's the way I suggest you do it. So this is all standard boilerplate, this motion here, so you can just pretty much copy it verbatim. You can make something up for the defense attorney, make something funny, I don't care. Use the same heading here, same format here. This defense counsel uses facts, argument, and conclusion as his headings, but he has a little introductory section here, again, with Di Benedetto. You're welcome to use that. You could probably copy this if you wanted to verbatim, I suppose. Yeah, you could use that. That's fine. I like to get right into it. My memorandum usually just starts right with the facts. It's up to you. All right. So anyway, the facts section, you're going to do the facts section, right? You're going to research your issues first, research your elements, and then figure out what facts are important for each element. Okay. So, and try to keep the facts, as brief. I give you a brief fact pattern. Okay. So it shouldn't be that difficult. All right. Argument, again, state the rule, make your argument, and then make a conclusion. I would like you, in your argument section, to have a conclusion sentence at the end of your argument. Okay. That would be therefore, because there is not sufficient evidence to support the element of blah, 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 or there is sufficient element. So you can list each one. So remember, you, the defendant, win in a criminal case if any of the elements are not met. So if you can find one, that's great. If you can find two, that's great. If you can find all the elements are not met, that's great. But you only got to find one. But that's fine. I've given you, like I said, I think some cases. There's some good cases that support arguments that, they can't prove some of the elements of drunk driving in this case, OUI. All right. The other thing is, after you state your rule and make your argument, you should find you should cite at least two cases, I would suggest, that support your argument. You could use the parentheticals that I used before, or you could cite the case and say, see Commonwealth versus such and such, or you could say, in Commonwealth versus such and such, then have the cite, here's what happened, blah, 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 blah. And then you could have a sentence that says, in our case, as in Commonwealth versus such and such, this happened. Therefore, the court should do what the court did in Commonwealth versus such and such. Something like that. You've read my briefs and some of the memoranda. You should hopefully have some idea of how to use cases that in a way that supports your argument. Okay, and that's basically it. So that's the format of the memorandum. At the end of the memorandum, again, you're just going to have a conclusion section. Remember, when we write a memorandum or a brief to the court, we have a conclusion section. It's not part of the IRAC. This is just part of the format of these formal format of these documents. And at the end of our document, we just have one sentence usually that says, I usually just say, for the reasons herein set forth, this case should be dismissed. Or you could say, for the reasons herein set forth, there is insufficient probable cause there was insufficient facts to show probable cause for the elements of blah, 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 period. Therefore, the case should be dismissed. But again, it's just a very, very quick, very quick sentence at the end. And that's it. These documents typically should also have certificates of service. I won't make you do those, but you should know what those are. Those are very simple, form documents that state and swear that you have served this document on opposing counsel, the date you served it, and the manner of service, whether it was first class mail, in hand, email, whatever it was. Okay, so good luck on this assignment, and feel free to call call me, email me if you have any questions. I'm open for Zoom meetings as well. Thank you. Okay, in this assignment, I'm asking you to draft a motion to the court and a memorandum of law to the court. We call that a supporting memorandum of law to the court. You should know what a motion is. A motion is simply a document in which you ask the court to do something. I want the court to dismiss the case. That's what this motion is to do. Very simple. One paragraph, maybe stating one supporting case, and then saying that for that reason, the case should be dismissed, or whatever you're looking to do. All right. And then the supporting memorandum of law, you should know what that is. That's a document that you give to the judge or the court that's more lengthy, that sets forth all the legal case law and rules that apply, and applies them to your facts, and argues that your position is supported by these cases, and argues for the dismissal of the case. Basically, it's a roadmap for the judge to follow. It's an argument to make. So you've got your motion to dismiss. I want you to do this. This is a good form to follow. You're going to follow this particular same form here. Excuse me, I'm trying to fix this here. This is not. Okay. So your motion to dismiss here. I'm going to pause here.